Good morning, ladies and gentlemen. I'm Beverley Spencer from the CLE group at the Law Society of Upper Canada, and I'm here to welcome you this morning to our program. Just a couple of brief points before we begin. First of all, please take some time and fill out the evaluation forms you'll find in your binders. They're very important to us in developing future programs. Second, I'd like to take this opportunity to thank our faculty. A group of very dedicated volunteers help bring you these programs, and I'd like to take this opportunity to thank them for all of the work they put into them. And finally, I'd like to introduce our chair for today. Michael Whitcombe is head of the corporate commercial group at Macmillan Binch. He's a graduate of Queen's Law School and holds a Bachelor of Business Administration. He teaches business law at the Bard Mission Course and is a member of the Business Law Subcommittee of the Canadian Bar Association, Ontario. Please help me welcome Michael Whitcombe.
Thanks very much, Bev. I'm going to have to update my bio as a result of the notoriety I've achieved as being chair of this program. I don't know how many times in the past month when I've been making an initial introduction to somebody, there would be a pause saying, "Aren't you the 6-minute business lawyer?" I say, "Yes, I am." It actually was used against me last week in the negotiation when things were not progressing as quickly as my client would have liked. So we got together on a conference call with the other side, and I was asked to make the point that things were not progressing fast enough. And the retort I got from counsel on the other side quite defensively was, "You may be the 6-minute business lawyer, but I'm not. This will proceed at the pace that I set." I want to thank everybody for coming. We've got a full morning. We have 16 speakers covering as many different topics. When I was asked to chair this program by Bev, we sat down and I said, "What do you want me to do?" And she said, "Well, can you come up with a list of 20 odd topics, current topics of interest to a business lawyer?" And I said, "Well, that's not going to be hard to do. In this age of specialization, still the breadth of topics and legal concepts that a business lawyer, general business lawyer, needs to cover is obviously quite broad." So it wasn't any problem coming up with a list of topics. Bev said, "And then can you please, find people to speak on each of those?" And once again, that was not difficult. I want to thank everybody who is speaking today for the participation and the professionalism they showed in getting everything done on time. I will share with you, I thought it was a funny anecdote. When I put the list of speakers in, I received a call from Kathy, the program coordinator at the back, who called me up, and it was my first discussion with her, and she goes, "Mr. Whitcombe, I have a problem with one of your speakers." And I'm thinking, okay, thoughts going through my mind. Here I put somebody on the list who's either being disciplined or disbarred. This is great, and I won't tell who's the first name that came through my mind when I got that call. Then I said, "What's the problem?" And she says, "Well, you do understand this is a 6-minute business lawyer forum." I said, "Yes, I understand it." "You do understand that people are only going to speak for 6 minutes." "Yes, I do understand that, Kathy." She goes, "Well, I see you have a lawyer, a New York called lawyer who's going to come and speak. And we have a budget." And I'm like, "Yeah, okay." And she goes, I really don't think that it's a good idea to spend all our budget on bringing in one lawyer from Buffalo to speak." And I explained to Kathy that actually George Eydt from Hodgson Russ, who will be speaking in the second half of the program, his office is closer to Osgoode Hall than mine is, and the transportation costs involved in getting him here would be half of what they were for me, which is one subway token. So on stage are all the speakers for the first half of the program. What I'd ask you to do is save up your questions. We have a dedicated question period, and then we'll clear the bench and bring in the round after the coffee break for the second half of the program. The speakers aren't aware of this, but we actually have allocated 33% more speaking time to each of them, so that they will each get 9 minutes. Now, I was handed this morning by Bev a lemon timer, a device unfamiliar to me. However, I've been assured that I'm supposed to set it at 8 minutes, which I understand is the length of time it takes to hard boil a lemon. Wasn't aware of that before this morning. It'll go off, and then there'll be 1 minute to finish up. So as I was allocated 18 minutes for opening remarks, which is the equivalent of 2 speakers, I don't intend on taking anywhere near that. And the next thing I'll do is introduce Rob Wilkes, whom I've known for almost 20 years. Rob and I went to Queen's Law School together. Back at Queen's, he was the engineer in the class, that guy that we couldn't quite figure out, but was a great hockey player and was into computers and that sort of stuff. And we kept telling him, "There's no future in computers, Rob. You should focus on being a lawyer." He's had a very successful career to date in combining both his background in electrical engineering and his interest in the technology side to a very lucrative and active practice at Blake Castles, where he's a partner in the e-commerce group. Rob.
Thanks a lot, Mike. It's interesting because we started with technology and a reference to technology. What you'll notice with e-commerce is it virtually has nothing to do with technology anymore. So my practice is shifting every single day, and that's the other thing that you'll notice about this area. It's changing every day. E-commerce is about commercial law issues, and so that's what we're going to talk about today. We set ourselves an impossible task. There are way too many topics to talk about them in 6 minutes, 8 minutes, 9 minutes, or a day. But the best advice I can give you if you're really interested in this area is to get on the internet and subscribe to news lists and discussion groups and that kind of thing, and you'll just see the issues will just keep coming back at you, and eventually it'll turn into a soap opera, and that's when you know you've begun to learn something. The best example I can give for Canada is the Uniform Law Conference of Canada discussion group on e-commerce, and that'll give you up-to-date references on legislative activities and other activities in case law and that kind of thing in Canada. What I'm going to do is just try to hit on some specific issues. It's sort of like, when you talk about e-commerce, it's sort of like saying, okay, we're going to explain aircraft, cars, boats, and planes are aircraft, all in one session. So that's the kind of breadth that we're talking about here. My materials, there's only one page, and as I mentioned in there, there's reference to our website, and I did that because if we took all the materials and put them together, we'd have about, well, hundreds of pages of material in effect. So look in there for Blake's reports on intellectual property, and also there's going to be a paper on e-commerce legal architecture that I'm putting up from a talk I did last month. And so what are the topics we're going to talk about? We're going to talk about online contracting, privacy, consumer protection, jurisdiction, and if we can get there, we'll talk about intellectual property. And online contracting, the focus is on writing, signature, and retention requirements. Do we need paper? Can we do this all online? And again, the Uniform Law Conference of Canada has adopted what's called the Uniform Electronic Commerce Act, the UECA, as a model law. And if you look at that and the discussion around that, we're taking that and now across the provinces. Saskatchewan had put in a bill. We thought it was going to go right through to law. They've withdrawn that bill in the last week, so that wouldn't have been in your materials. And they put forth a new bill, and it's dealing with all of the writing, signature, and retention requirements. Ontario has a bill on the books from a backbencher, Bill 70, and that just came in the last week or so. And whether it's going to go anywhere, we don't know, but it's basically based on the UECA. If you, what's nice about these documents is they provide some best practices. Do we need paper? What would we do if we can't have paper? How would we reflect that in an online context? And what you have to do is get the documents out there and get them ready, get them available to people so that they can download them, they can print them, they can retain copies. That's the kind of best practice that we're talking about with writing requirements and original copies. Signatures is a bit more difficult, but in 6 minutes or so, I'm going to move on. We do have an Ontario case, Microsoft and Rudder, that deals with click-through agreements. These are the kind of agreements that you see online and how you make an online contract. Read it with a grain of salt. The background facts are a little bit tricky. I don't have time to go into them now, but what you might note out of that is there is a very nice exclusive forum clause and a jurisdiction clause in there, and there's also an example of an online click-through agreement. And just to show you the other side, there's a US case that just came out that basically said if you have online terms and conditions and you put them behind a link, and it's sort of an innocuous little link, that's not going to be enforceable. All those online terms may be worthless. So these are the kind of issues that you want to think about. Privacy. Bill C6 has just been passed, and it comes into force January 1, 2001 for federally regulated sectors and interprovincial activities, and January 1, 2001. And it will apply to health information January 1, 2002, and it will apply to provincial activities, provincial commercial activities, January 1, 2004, unless the provinces enact corresponding legislation. So they've got a bit of a three-tiered scheme. Whether it works constitutionally, we're not quite sure, but basically the feds are trying to push the provinces into getting on side and everybody having corresponding legislation on the privacy side. What's it mean? It protects personal information of identifiable individual, and you cannot collect, use, or disseminate that information without the individual's consent. But the only thing it doesn't include is the name, business address, and title of the person. So you see the scope of the information that we're talking about, and you can think of all of the different areas where people are collecting this type of information and the kind of programs that you're going to have to put in place for your clients and the issues that they're going to have to think about. The consent has to be for a limited purpose, so you can't get a general consent. You can't just go out there and say, we can collect any information we want about you and do whatever we want with it. It has to be, you can possibly have implied consent. It can deal, so the individual can, if the purpose is, would be evident from the way in which you're collecting it, the information, then that might be an implied consent. For example, or might entail an implied consent. For example, if you collect information for a magazine subscription, presumably you're allowed to use that to send the magazine out to an individual. But it's better to obtain express consent. There is Quebec legislation in place on privacy already. There is European legislation, and in the United States, they're getting on board on privacy issues as well. And again, you have to look at the materials to learn more. Consumer protection, big issue now on the internet, because there's a growing concern among individuals as to what's going to happen. I'm going to do it. I'm going to take up 6 minutes of your introduction. Okay. Watch the existing consumer legislation because it has writing, signature, and retention requirements in it. And there are cooling off periods, and you have to you'll have to decide whether this is the place of business, a website is the place of business of the business, or whether perhaps you're an itinerant seller and you're now off in the consumers doing business with the consumer off-site every time they're on your site. I'm not sure that that makes sense, but you have to decide for yourself whether you think that that site is the place of business of the business. And again, you want to consider the UECA best practices for your writing, signature, and retention requirements, and do they apply? Do they give you some advice? Then you can look beyond that legislation to guidelines, for example, that the Industry Canada has put out. And these aren't law, but they're very helpful to tell you the kinds of things that people want to have done with their websites and how consumers want to be dealt with. Disclosure, clarity, ability to remedy mistakes, and the availability of remedies are all things that are dealt with in those guidelines as general issues. Jurisdiction, obviously it's a huge issue on the internet because once you're up there for the world to see. And how are you going to deal with that? Well, what can you say to a client at that point in time? You can do your best to spot the issues. You can keep up with as much information as you can all around the world. Good luck. And you can consult foreign counsel. Good luck there too. It's obviously a very expensive thing to do. But there may be very serious issues there on a tax side. Where do you locate your server? In what jurisdiction are you doing business? Regulatory issues, whose law applies? And civil jurisdiction, can you get sued all around the world? There is a Canadian case on jurisdiction, Brain Tech. but it's next to useless because the facts are so entirely one-sided that the case could not have been decided any other way but the way it was decided, and the judges don't really go into the bottom line law or detailed statement of the law. And look back at that Microsoft and Rudder case when you're dealing with jurisdiction because of that clause that I mentioned before. If you're dealing with it and you can say what you're dealing with on the, if you can contractually say what jurisdiction you're going to deal with and where you're going to be sued, perhaps that's going to help you later on. Intellectual property, the only thing I'm going to say, I'm going to mention two things. Patents, very big issue. Want to consider protecting patents for business methods and protecting inventions for business methods and that kind of thing. And the other is domain names. We're going to be changing our domain name registry in Canada so that you can register as many domain names as you like for a company. At that point in time, it'll be a race to register all of these. So if you have companies that want to register more than one domain name, because that's all you're allowed right now in Canada, take a look at the rules there and get ready because everybody's going to be in that horse race to register all of those domain names. And copyright, always a concern. Get your assignments of copyright when you're dealing with website development and that kind of thing for the content, for the software, as much as you can get. That is the whirlwind tour of e-commerce today. Sorry I took some extra time. Thanks.
Thanks very much, Rob. Next speaker is Wayne Gray. Wayne was on the West Coast for, I guess, the early part of his career and then saw the light and came to Toronto a number of years ago as a partner at Miller Thompson. I had the privilege of serving with Wayne on the OBCA and CBCA advisory subcommittee of the Canadian Bar Association for a number of years. I just would summarize by saying Wayne's depth of the corporate law statutes in my experience is unparalleled. So, Wayne.
Thanks, Mike. I'm going to talk very briefly about corporate jurisdiction shopping. This is probably going to amount to, I would say, a minority of the cases that come before you, but it's always important to give value added for every case. I think most Ontario lawyers, and the statistics show as part of my article, that most Ontario lawyers would approach it, and across Canada, it's pretty well the same, that you incorporate under the local jurisdiction unless there's compelling reasons to either go federal or go to another province. So it seems to me that an Ontario solicitor faces two questions. One, on what circumstances would you go federal? And second question is, in what circumstances would you go beyond that to another province or territory? And on the first question, I think that there's, in the last few years, since about 1994, there's been a convergence of federal and Ontario laws, so there's very little difference between the two statutes, except for minor details, and they're getting more similar all the time. In 1994, the federal government repealed the rules dealing with audited financial statements and disclosure of audited financial statements, which were a big barrier to incorporating under the federal jurisdiction up to that point. It's still true, of course, for public companies, but what the real problem was disclosure for large private companies, and that was a big barrier. And people still think that exists today, so it hasn't been the case since 1994. And then shortly thereafter, Ontario started to amend its provisions that required a mandatory audit even for sole shareholder companies, and over time that has disappeared. So the laws are the same basically in that regard. What are the differences today between the CBCA and OBCA? Then why would you go federal versus Ontario? I would say that I would pin it down to this. I think the Ontario statute is obviously a lot easier to get a name clearance in Ontario. Ontario does not provide any kind of name advantage, and you can't incorporate an identical name, but anything else basically goes. You're going to face the music if you've incorporated under somebody else's name or similar to it. But that's a private matter, not an incorporation matter. It's also a little cheaper to go Ontario, $170 when the initial filing fee, and then $50 a year you save yourself by not filing the federal annual return, so you can take the discounted present value of $50 into the future and add $130 to that, and that's the cost saving. The advantage of a federal incorporation, I think, are basically come down to two things. One is that in some cases it will be a nice platform for if you have investors or directors or officers or lawyers in more than one jurisdiction. It can be useful for all of those players to have a common statute that they can work with and feel that they're getting some national representation. And I think that's probably the driving reason why approximately one half of the Fortune, the top 500 corporations in Canada are incorporated federally. The other reason that's often given for federal incorporation is name protection. And it does offer a little bit of name protection, but I think it's a very narrow type of name protection. It's not a substitute for a trademark, that's obvious, because it doesn't really give you adequate remedies, and it doesn't give you exclusive use to the name. What it does give you, if you're incorporated federally, is the ability to go into another province down the road or another territory down the road and use that name as of right. And that can be an advantage for some. So you're trading off a bit of extra cost for that advantage. Let's turn then to the second question, which is the question of why would you go beyond the OBCA or the CBCA to incorporate another jurisdiction? Until recently, there were 4 reasons, and Mr. Scavone will speak to one of those reasons, which is, I think, basically gone by the boards now. But the 3 current reasons why you would go to another province come down to the following. The Canadian residency requirement. 7 jurisdictions in Canada now have no Canadian residency requirement. Ontario and the federal are 2 of the ones that still have it. The federal is going probably down to 25%, unless the Canadian Bar Association submission is successful, in which case it will go down to 0. Ontario still has a majority, except if there's a two-man board or 2-person board. So you can go to another province if you want to avoid that requirement. And the leading province to avoid the residency requirement is currently New Brunswick. New Brunswick because it's a CBCA model statute, and so it's very familiar to us and very familiar to most of the other practitioners in the country. But other ones that are also CBCA model that you can go to are Yukon. You see a few Yukon incorporations, particularly of public companies. And now Northwest Territories and Nunavut also have this relaxation. So that's one reason why one would go. And that would typically be a foreign investor situation where you can't find somebody to sit on the board and take the risk. Second circumstance would be if you're dealing with a particularly American investor who's coming into Canada but wants tax treatment in the States as either a partnership or a branch. There's only one vehicle in Canada that allows a foreign American investor to receive branch or partnership tax treatment, but at the same time have corporate law treatment. And that is to incorporate under the Nova Scotia Companies Act as an unlimited liability company. And there's some details in the paper about how you do that and how you can convert an existing company into a Nova Scotia ULC. It's not easy, but it can be done. The third reason is a little more esoteric, and it would come up fairly infrequently, and that is in certain corporate transactions, and it hasn't come across too often, one would need to have a subsidiary hold shares or acquire shares in a parent company as part of some kind of corporate reorganization. And neither the OBCA nor the CBCA allow that. And so there's the leading jurisdictions where that's permitted, this is called corporate incest, are Nova Scotia, again, and British Columbia also allows this. They have the old British companies model statutes, which do not have those restrictions. And again, the CBA has proposed that the CBCA be amended to allow that as well. And the fourth reason traditionally was to avoid some of the financial assistance reasons. But with the passage of a recent amendment in Ontario, which I won't speak to, that doesn't seem to be such a big advantage. A lot of lawyers were going to either New Brunswick, where you could opt out, or Saskatchewan, which had a disclosure to shareholder regime. That's it.
Thanks very much, Wayne. Next speaker is Rob Scavone, a partner of mine from McMillan Bench, who will be speaking on the recent amendments to the financial assistance provisions of the OBCA.
Thanks, Mike. March 27th, 2000 was something of a red letter day for lenders and corporate borrowers in Ontario and some of the lawyers that act for them, because on that day, the restrictions on corporate financial assistance in Section 20 of the OBCA all but disappeared. The amendments came into force on that day under the wonderfully named Red Tape Reduction Act. Shortly before this session started, Wayne Gray advised me that there are some additional amendments to that section which I've not had a chance to review. They may have some impact on what I'm saying this morning regarding some of the problems that still remain with Section 20. If you do any work for corporate lenders or borrowers, you'll know that Section 20 in its former guise prohibited corporations and their affiliates from giving loans, guarantees, or other forms of financial assistance to shareholders, directors, officers, employees, and associates of all these people, unless the corporation could pass a difficult double-barreled solvency test or could shelter under one of the statutory exemptions. Financial assistance in connection with purchasing the company's own shares was also subject to similar restrictions. The provision was presumably intended to protect minority shareholders and creditors from having the corporation's assets stripped away by what are essentially related party transactions. But it was so difficult to apply in practice and so difficult to interpret that more often than not it ended up putting up unnecessary roadblocks to perfectly legitimate transactions and tended to hold up financings so that the lawyers could figure out how to get around Section 20 by restructuring the deal or in a worst case scenario, even moving to another jurisdiction, as Wayne indicated. Lenders would ask for guarantees from subsidiaries and affiliates in a corporate group only to find that they would be unenforceable because of the financial assistance restrictions. The section was notoriously badly drafted, and a variety of questionable avoidance techniques evolved to get around the restrictions, such as back-to-back guarantees to permit guarantees between sister corporations. With the amendments to Section 20, most of these problems will be history. The amendments are included in the materials in your binder. Briefly, Section 20 sub 1 now provides that a corporation may give financial assistance to any person for any purpose by means of a loan, guarantee, or otherwise. So essentially, it is now a purely permissive section. The only remaining requirement is that the corporation disclose material financial assistance to its shareholders after the fact. For non-offering corporations, the disclosure is to be made by a notice to all of its shareholders within 90 days after the assistance is given, so it's a fairly generous time window. For offering corporations, the disclosure is to be made in each management information circular for each meeting after the assistance is given, or if there is no management information circular, then in the next annual financial statements. The amount of information that's to be given in the disclosure is fairly minimal. It's a brief description, the terms on which it's given, and the amount outstanding. There are a number of points to note in the new section. Again, the permission as it's now drafted, and I'm not sure if the technical amendments have addressed this point, but the permission is unconditional. That is, it's not subject to compliance with the disclosure requirement. This is unlike the Saskatchewan provision, which is very similar to this. The Saskatchewan Act makes it clear that the power to give financial assistance is subject to disclosure. The Ontario version does not say that. Subsection 1 does not say subject to subsection 2 or the rest of the provision. There are now no solvency tests. The exemptions are still there, but they apply only as the threshold to disclosure, not as a threshold to the power to actually give the financial assistance. There is no mention in the new section to direct or indirect financial assistance, which was a problem with the old section. The disclosure requirements now apply to assistance given only by the corporation itself, not by its affiliates, so the scope is somewhat narrower. Also, perhaps inadvertently, the web of associates who are caught by the assistance is a bit narrower than it was under the former provision. It used to say any associate of a shareholder, director, officer, employee of a corporation or its affiliates were caught as well. The new requirement only applies to associates of the corporation or the affiliates, not the other members of that long and difficult to apply list. The statutory exemptions are essentially still there, but again, they apply only to the threshold requirement of whether you have to disclose the assistance or not. The only one that's missing is for employee stock option plans. I can only guess why that was omitted, but presumably because that sort of financial assistance would ordinarily not be considered material, so it wouldn't have to be disclosed in any event. There still are some uncertainties as to the interpretation of Section 20 as it's now drafted. They essentially center around what it means not to comply with Section 20. As I said before, there is actually now no prohibition against giving financial assistance. It's purely permissive. And in fact, strictly speaking, you wouldn't even need subsection 20 sub 1, which permits a corporation to give financial assistance, because of course, under the Act, the corporation has all the powers of a natural person anyway and would be permitted to give financial assistance. I assume that that section is in there for greater certainty because the prohibition has been around for so long. As the section is now drafted, non-compliance with the disclosure requirement should only be a breach of the Act, that it should attract the general penalty provisions, but I would argue that it should not invalidate the giving of the financial assistance. Again, because the opening subsection is permissive and it is not subject to disclosure. The only caveat that I would have there is that we still have what is often known as the safe harbor provision in subsection 20 sub 7, which says that a contract made in contravention of this section is enforceable by the corporation or by a lender. So the question is, why do you need that if the section is purely permissive? It seems to imply that if you don't disclose, it's not enforceable, but that's not actually what it says. Director's liability is also another question mark under the amended section. Subsection 130 sub 2 sub A has not been amended to take into account the new financial assistance provisions. Directors are still liable for financial assistance given contrary to Section 20, but again, the question arises as to what is financial assistance given contrary to Section 20 if there's no prohibition against it. A couple of caveats to keep in mind. The amendments only apply prospectively, that is from March 27, 2000 onward. They will not cure transactions that were concluded before that date. Also, you have to make your clients aware that the amendments to Section 20 don't give the corporation carte blanche to give away money to related parties. The directors are still subject to their general fiduciary duty to act in the best interest of the corporation. A minority shareholder or indeed a creditor would still have available the usual arsenal of remedies that they now have, such as the oppression remedy for financial assistance that unfairly disregards their interest, or fraudulent preference legislation and other insolvency remedies. The walls against financial assistance seem to be tumbling down all over Canada. Alberta has recently enacted similar amendments. As we've seen, the Saskatchewan provision has been in effect for a number of years, as has the one in New Brunswick. The CBCA will soon go a step further. The new package of CBCA reforms under Bill S11 will repeal Section 44 altogether. It's not subject to disclosure requirements or anything. It's just gone. All of this should make life a little bit easier for corporate lawyers and borrowers, and not to mention their lawyers. Thank you.
Thanks very much, Rob. The next Robert, also at Macmillan Bench and also a tall, thin type, is Robert Wisner, one of our associates in our practices commercial litigation, who's going to speak about terminating a distributorship.
Thanks, Michael. I was asked to speak about terminating a distributorship, which presumes that you will be acting for the person doing the terminating rather than the one who's been terminated. However, I think all of the points that are made in the paper and in this talk can apply just as much if you will be acting for the dealer or distributor, and the paper would probably just be titled 6 points to consider before suing your supplier or manufacturer. There are a lot of cases involving litigation between dealers and manufacturers, and that's because the dealer will have usually invested a lot of time, money, and effort into building up their business, and the termination of their dealership agreement will often mean the loss of a large part of their business. So if you are acting for a supplier and you're being asked to advise on the termination of that relationship, be prepared for the fact that anything you do will likely appear in court, or could likely appear in court, because the consequences are fairly severe. The first step in providing your advice is to ask for the contract. And if you're lucky, you will have a client that will have signed with their dealer or distributor a formal written agreement that has an express termination clause in it. And that express termination clause will usually be one that, if the agreement is for an indefinite term, will provide for termination with or without cause in 30, 60, or 90 days, or some other period like that. Even in those simple cases, though, you will often find that the counsel for the plaintiff, for the dealer or distributor, is quite ingenious in finding ways to get around those kinds of provisions. For example, they will say that, sure, we signed an agreement that said there was a fixed term or there was a 30, 60, or 90-day termination clause in it, but that provision was superseded by some other agreement that we had later on down the road. There will often be some kind of evidence to justify that kind of an argument, and that's because dealer and distributorship agreements are long-term relationships. And during the course of these relationships, when things are going well, the supplier will often make some kind of a statement, perhaps very casually at a Christmas party or some other kind of event, about how much they value this relationship and how we expect to be doing business for a long time in the future and for many years down the road, so that the terminated dealer or distributor may then turn around and say, you see, we had a contract to amend our original agreement to provide for a longer notice period. The best way to avoid that kind of situation is to have in your original agreement an entire agreement clause that specifies that any changes to the agreement must be made in writing and must be signed by both of the parties. Often you will be faced with a situation where the distributorship agreement was started in a fairly casual manner, perhaps by an exchange of letters or perhaps without any writing at all. You then have the dilemma of trying to figure out what a reasonable notice period is. And there is no set formula for calculating a reasonable notice period. And unlike employment contracts, there are a lot more factors that you will have to consider in calculating a notice period for the dealer beyond simply the length of service or the history of the relationship. Among these factors are how much of the dealer's business is done with your client, the manufacturer, what are the standards in the industry. You might look at standard form agreements by your competitors and see what they provide in terms of notice period. Other factors will include whether or not the dealer carries inventory or whether or not it's an exclusive dealership agreement. And the theory behind each of these factors is that the dealer requires some time to reestablish themselves in another line of business, and so the amount of notice that is to be provided will depend on the nature of the product itself. If it's a fairly straightforward kind of a product and there's no inventory that's being acquired under the terms of the relationship, it hasn't been a very long relationship, 60 days may be sufficient. Otherwise, there are a number of cases that will provide for up to 1 year's notice. And there's even a very recent decision that for the first time provides what I think is the longest period ever granted, which is 2 years. It is a case that is based on fairly extreme facts involving a 20-year relationship, however. Now that you've calculated the notice period that you're going to give, it's important that you provide some form of business justification in your notice letter or other written communications that you may want to offer to the dealer. And the reason for that is that termination letter may show up in court. It might not show up on the front page of a newspaper, but it'll show up in court. And if it's a one-sentence termination letter that simply says, please be advised that your agreement is hereby terminated effective this date, plaintiff's counsel will get up and make a closing argument saying, my client spent 10 years pouring his blood, sweat, and money into this business, and this is a one-sentence letter that he got at the end of the day. It's helpful in those kinds of cases to show to the court that there was a valid business justification that demonstrates that your client was acting in good faith. For example, if there has been a move to consolidate the dealership network or to vertically integrate such that the corporation will be doing the distribution itself, it may be useful to make that clear to the dealer. I'm glad to see that one of the other speakers today will be talking about good faith in commercial contracts. It is now mandatory for plaintiffs in dealership context to plead good faith, and it's almost negligent if they don't do so. And the reason for that is that the law is fairly uncertain, and it's difficult to predict what a court will do with a good faith argument. There is some helpful authority that provides that notwithstanding any duty of good faith, you can't use that kind of an argument to rewrite your termination clause to provide for a longer notice period. And so if the termination clause is quite clear, it will be limited to the amount of time provided for. However, there are other situations in which the contract might renew automatically, there's a discretionary power, and the court might say that in those kinds of cases, that discretion has to be exercised in a good faith fashion. Don't forget that for the remainder of the notice period, the dealer is still has entitlements under the contract. Get ready to tie up all the loose strings when that notice period expires by arranging for the return of inventory and trademarks. Finally, if you are asked to terminate a dealer for cause or for misconduct, make sure that you have a lot of evidence to document it, and make sure as well that written warnings have been given to the dealer. In many cases, it's very hard to prove cause. It's like an employment contract. Courts will try not to make a finding of cause if they can avoid it. And finally, ask your client why they are terminating this dealer, and make sure that the answer is not because they've been discounting my product. Because if they say that, they're violating the Competition Act if they terminate your dealer. And you may not only have a lawsuit on your hands, but you may have a criminal investigation with the Competition Bureau. And my last point is that there's a fairly obscure provision in the Competition Act as well that you usually don't have to worry about. It's called refusal to deal. It's, as it stands now, it's a power that only resides with the Competition Bureau to investigate certain cases where there's a lack of competition in the market and there's a refusal to supply a product. There are amendments, though, that are pending to the Competition Act that may allow dealers to bring private applications to the Competition Tribunal. Keep an eye out for these amendments in the future. They may come into effect.
Thanks very much, Rob. Next speaker is Jane Ratchford. Jane's a partner at Bolger Rubinoff, who has also spent a couple of years working for the Law Society as discipline counsel. She specializes in security and stockbroker litigation, and having this past weekend opened up my most recent RRSP statements from my broker, I have a lot of personal interest in her talk as she's about to.
Thank you, Michael. This topic has turned out to be much more timely than Michael and I realized when we first spoke about it about 3 months ago, and that's really for two reasons. First, the roller coaster that the stock market has been on for the last several months with no end in sight, and secondly, the release by the Supreme Court of Canada of a decision in early May in Laflamme versus Prudential Botch Commodities Canada. And this was the case that was behind some of the catchy headlines that you may have seen in the Globe, and more particularly the National Post. Brokers liable for bad advice, High Court says. And I thought that rather than reviewing the contents of my paper, which sets out a number of the key concepts which you should be aware of if you are going to embark upon litigation in this area, in suing an investment advisor, also commonly known as a registered representative, and the investment dealer that they work with, that it might be worthwhile just spending the few moments that I have reviewing this case with you, as it sets out a number of the concepts and underscores the concepts that you're going to read about when you read the paper. The National Post article, the first paragraph starts off, "The Supreme Court of Canada yesterday ordered a stock brokerage to pay more than $2.3 million to an investor, handing down a ruling that may open the industry to an avalanche of costly lawsuits and that will certainly be poured over by financial firms across the country." Now, yes, I'll agree that financial firms may have an interest in reviewing this case, but I have to say that in my review of at least the English translation of the case, because it's a case that came up through the Quebec court system, through the Quebec Court of Appeal, and to the Supreme Court of Canada, I really don't see that there's much of anything new here. And while this is a very catchy headline, I don't see it as opening the floodgates to litigation against stockbrokers and the registered representatives that work for them. This particular case can really be distinguished on its facts, but it gives you one of these types of examples where it's really extreme on one end. This was a case of a 60-year-old gentleman who was a self-made man, had a grade 4 education, had no prior experience dealing in investments, who sold a door and window business for about $2 million. And he invested this money with an investment dealer, Burns Fry, and in particular, the gentleman who was taking care of his investments was a Jules Roy. Now, in this particular case, Mr. Roy was acting as a portfolio manager, which means that he was managing the affairs of Mr. Laflamme, and he was responsible for making all the investment decisions. In essence, it was what you call a discretionary account, where the registered representative or investment dealer, as they're also known, is making all the decisions. Now, the way that that is accomplished is that an investor executes certain documentation, a discretionary account agreement, that then provides the authority for the registered representative to do the trading. Now, of course, notwithstanding that the registered representative has this power to make investment decisions, he must still meet and follow the cardinal rule of an investment advisor, which is to know your client. And I talk about that in the paper. Knowing your client is knowing the investment objectives. Do they want long-term security? Do they want long-term growth? Do they want to engage in speculative transactions? Is it a mixture of those three concepts? What is their risk tolerance? What is this person, the investor's net worth? What is his or her investment knowledge? Have they been involved in the stock market before? So those are all the mix of things that go into knowing the client. And notwithstanding that a registered representative may be acting pursuant to a discretionary account agreement, he or she must still trade within the objectives for that account. And what happened in this particular case is Mr. Roy had the investor, Mr. Laflamme, sign documents in blank. He signed off on them and didn't learn until about a year into things that, in fact, Mr. Roy was conducting trading on margin. And I've covered that in the paper as well, but margin is where the investor borrows a very high percentage of the amount of money needed to make an investment from the investment dealer. They put up a small percentage of it, and then can increase the amount of trading that is done because you have that much more leverage. But it is a very risky way of trading, and certainly is something that should be fully explained to the investor when embarking upon that type of trading. And that's something that Mr. Laflamme had no idea about. And the matter went, the trading went on for about 3 years. At one point, Mr. Laflamme and the family learned about the trading on margin. They wrote to the investment advisor, told them to stop doing this. They did at some point in time become a little more involved in some of the decisions in respect of the account, but ultimately the account sustained huge losses, and Mr. Roy, who in the meantime as well had moved over from Burns Fry to Prudential Bach, and again, or Botch, and again had had documents signed in blank, most of the account value was lost, and hence there was an action commenced in the High Court, Superior Court of Quebec. And what's interesting is the court found that indeed Mr. Roy had been negligent in how he had managed the account of Mr. Laflamme, and he found a number of what are described as gross faults. Failure to be properly knowledgeable about his client's situation, failure to act in accordance with the client's objectives, failure to adequately inform the client concerning the nature, return on, and risk of the investments, failure to comply with the client's specific instructions, failure to deal with his client in good faith and in accordance with good practices, extremely large number of transactions for the purpose of increasing commissions, which is churning, which I've also covered in the paper, failure by the defendant company to exercise proper supervision, and a clear conflict of interest as Mr. Roy's supervisor was also sharing in the defendant's commissions. And there was expert evidence, as there often is in these cases, and there was an award of damages, including the return of commissions earned on the improper trading and interest on the margin account or margin loans. The matter went to the Court of Appeal. The Court of Appeal did not disturb the findings with respect to the negligence, but decreased the amount of damages because they were of the view that when the family became involved in the trading of the account, that the account changed from a discretionary account to a non-discretionary account, and the family had to assume some liability. Went to the Supreme Court of Canada. Again, the findings with respect to negligence remained untouched, but the trial decision with respect to damages was restored, save and except for there was a bit of double counting on the commission that was straightened out. So the heads of gross faults that I've outlined from this case are really the types of claims that you might be making if you are consulted by an investor. My advice is to get to know your own client, get to understand what their investment objectives were, what their understanding was as to how the account was to be traded, and once you've ascertained all of that, you can determine whether or not it's a proper case to sue their financial advisor. Thanks.
Thank you, Jane. There'll be no need for us to meet later on to discuss my own case. Next speaker will be Jeffrey Lem, who's a partner at Heenan Blakey. Jeff's going to talk about using title insurance to get your deal closed.
Ladies and gentlemen, imagine, if you will, a relatively tough transaction. Let's say it's cross-border. You got your pension issues, you got some IP issues, usual tax problems, shopping for jurisdiction, but you've got all these problems dealt with. It's the morning of closing, you come into your office, you look at your telephone. And if your telephone's like my telephone, it has a little light that comes on to tell me that there's voicemail. We call that in our office the flashing beacon of death, okay? The light is flashing, you pick up your voicemail, and it's none other than a message from your real estate partner, and it goes something like this. Hello, Bob? Yeah, Bob, this is Jeff. Jeff from the real estate department, short guy, glasses, pocket protector. Remember, you asked me to look at some of the real estate issues that were related to this big transaction that you have closing today. I thought I'd give you a call and just alert you to some of the issues that we've come across in reviewing this real estate portfolio. You know that big property you have in Mississauga, that huge plant of yours? Well, geez, it seems like about 30 some odd years ago, there was a bit of a weird transaction in the chain of title. It seems that an Edward A. Smith acquired the property, and 5 years later, Eddie Albert Smith sold the property. Needless to say, we can't tell you that it's a good chain of title. Now, between me and you, Bob, and off the record, I think it's probably okay. We haven't heard a claim in 35 some odd years. I'm sure it's fine, but we just simply cannot opine on it. And you know that big factory you have up in North Bay, that real big processing plant you have there? Gosh darn it, if it ain't the most closest perfect example of a near breach of the rule against perpetuities. Bob, we don't get those too often in the real estate department. It's a real beaut. In fact, it's so interesting. We're having a special ad hoc meeting of the real estate lawyers this afternoon, and it's on the joys of the rule against perpetuity, and your North Bay plant is the perfect example. Now, Bob, as between me and you, I don't really think it's a breach of the rule against perpetuities, but that's a tough neck of the woods, and we're not going to provide any opinion whatsoever on whether or not you're okay or not. And you know, Bob, you know that plant out in Napanee? Well, as everyone knows, the Napanee Civil Service has been on strike for some weeks now, and quite frankly, although we've had a chance to take a boo at the Land Registry Office, all of our off-title inquiries have gone unanswered, and there's no likelihood that we're going to get any answers, not even verbal, by your closing today. So, Bob, we can't quite tell you that that widget plant is actually zoned to be a widget plant, nor can we tell you if Ottawa Carleton's big expropriation plans are actually going to cover your plant. Now, Bob, as between me and you and off the record, right, it has been making widgets for 30 some odd years. I doubt if it's illegally zoned. And we know that Ottawa Carleton is expropriating on the other side of the river, so it's not likely to affect your lands. But that said, Bob, we're not putting an opinion on that one, that's for sure. Now, ladies and gentlemen, Bob and Jeff are mythical characters. But I'm sure that every single one of you have come across a transaction where you found yourself in Bob-like situations, right? That is always going to be a risk every time real property is a major component of the assets being acquired or financed, okay? Now, many, many times you'll have these problems, requisitions as we like to call them in our game, and they can be dealt with through a combination of reps, warranties, undertakings, indemnities from the vendor, okay? So you do have a problem, the vendor will represent that, yes, in fact, it is zoned to make widgets, and he'll back it up with some sort of an indemnity. However, there are certain times when that type of an approach will not work. Sometimes the vendor simply will not give you any sort of an undertaking, rep, warranty, or indemnity, or other times the vendor will be more than glad to give it to you, but it'll be worthless the moment you close. In those circumstances, somebody has to make the decision of how to allocate the risk. The risk is probably small, but who's going to allocate it? It's certainly not going to be your real estate department. If they're half prudent at all, they're not going to opine on these issues. Is it going to be your client? Maybe, maybe not. A new alternative is now on the scene, title insurance. Title insurance, as its name implies, an insurance policy. It can be purchased for the benefit of the buyer. More importantly, it can be purchased for the benefit of the lender who's going to lend against the security of that real estate. Title insurance is ideal for covering off these requisitions that are potentially catastrophic, but probably aren't a risk, okay? There are a few other reasons why title insurance may be actually a very useful tool in closing off these deals. Number one, if you have American clients, especially American lenders, many American jurisdictions, lawyers don't even give title opinions. Everything turns on the title insurance policy. Americans, far from me to say that Americans are a tad obstinate, it's very difficult to convince them that you don't need a title insurance policy, and it's much easier to switch than to fight. So if you have American clients, that's a great way of just getting the deal closed. Another one that has always been a problem for me is multi-registry office closings and multi-jurisdiction closings. So you've got property in Nova Scotia, property in British Columbia. Nobody's going to release any funds until the mortgages are registered in Nova Scotia and British Columbia. That narrows down the window significantly as to when you're going to close. although it's exacerbated when there's multi-jurisdictions, the same sort of problem happens even if there's lots of plants inside Ontario or lots of properties, because you know the game. We're all sitting around a boardroom table waiting for agents from various areas in Ontario to phone in to say that everything's been registered before you release funds. If you have title insurance, it guards against, amongst other things, improper registrations, so you can release the money in a civilized manner at a civilized hour and then verify that everything's been registered later. And a final reason why title insurance could be a very good thing, and one that warms the cockles of my heart, is an issue of liability. Title insurers will not, or say they will not, sustain subrogated claims against lawyers who give title opinions. So here's how the deal works. You give the title insurance company a title opinion, they issue a title insurance policy to your client. If something goes wrong with the title, the client calls upon the insurance proceeds, they pay out the insurance proceeds, and in theory, they do not sue you. And you know, partnership's a beautiful thing. For all you guys in here, guys and gals in here who are business lawyers and corporate lawyers, your partners are real estate lawyers, and it's your liability as well as their liability. So, if the title insurance company will not sue the law firm that gave them the original title insurance policy, it's a delightful little thing that you should keep in the back of your mind. It's also particularly useful if business lawyers are forced to somehow dabble in real estate. It's an area you ought not dabble in, and this is a great extra layer of protection for yourself. Now, lest this be said that this is a title insurance love-in, there are a couple cons, right? One, cost. Like everything, you have to pay for it, although, frankly, I do not find the cost to be prohibitive, and my clients have never complained about the cost of title insurance policies. Typically, you're running $1,000, so that's 10 basis points on the market value of the real estate that you're title insuring. That's pretty reasonable. So I don't really consider that a con. The second con that I have is be very careful about consequential damages, okay? The title insurance policy will guard you against the loss of that particular piece of real estate. So it's the fair market value of that particular piece of real estate. If, however, that real estate is the linchpin of the entire business operation, and if that particular site goes down for even 10 minutes, and your entire business falls apart, then using title insurance to protect the title of that piece of land is not the prudent way to go. It's better to do your full due diligence and figure out the problems. And thirdly, and as the last and final con that I have with respect to title insurance, it is, after all, insurance. If anyone has ever had to make casualty claims and had to fight with an adjuster every tooth and nail to get any dollar out of the insurance companies, one's got to think that, well, maybe you might have the same problem with title insurers. I don't think it's a problem specific to title insurers, but the industry is so new in Canada with it's only been in play for about 5 years. There have not been enough catastrophic claims to understand whether or not title insurers will actually deliver. And like I said, if they're anything like casualty, life, financial guarantee insurers, the big ticket is in the payout, right? Will they pay out? And only time will tell that one. Thank you very, very much.
Thanks, Jeff. Very informative, very entertaining. I should have warned you before you started that that tall gentleman sitting beside you is a graduate of Johns Hopkins and Yale and is an American. Next on the list is Ken Wiener from Goodman, Phillips & Weinberg. Mr. Wiener is a partner and securities law specialist who's going to talk to us about employee stock option plans. If any of you read the most recent issue of the Canadian Lawyer magazine and saw the what I thought was quite amazing stock option privileges which in-house counsel are now assuming, this might be of interest to a lot of us in the room.
Thank you. The reason we're all here is because we don't have stock options. Employee stock option plans are becoming a more and more significant aspect of compensation for both public and private companies in Canada. Under a stock option plan, executives and/or employees are granted options to purchase shares from Treasury at a fixed price for a defined number of years. The increased importance of options are in part due to the dot-com companies, where there is a chance of a large payoff within a very short period of time. But it is also true within large public companies. William Mercer did a study of 50 large Canadian companies in 1999 and found that CEOs receive 57% of their compensation from long-term incentive plans such as stock options. And of course, stock options are a very good reason to be an in-house lawyer as opposed to practicing with a law firm. I'm going to talk to you for a few minutes about option plans for public companies and the rules of the Ontario Securities Commission and the Toronto Stock Exchange that are applicable. Under our Securities Act, a public company granting options to employees in Ontario needs a prospectus exemption to grant the options, and also needs a prospectus exemption to issue the shares once the options are exercised. In addition, the option holder needs a prospectus exemption to be able to sell the shares on the open market once the options are exercised. The Ontario Securities Commission has adopted Rule 45-503 to cover the grant of options to employees, to executives, and also to certain consultants as described in that rule. Once the option is granted, you'll look to Clause 72(1)(f)(3) of our Securities Act, which covers the exercise of the options. Section 725 of the Act then allows the sale of the shares on the TSE, but only if the company has been public for 12 months. It's important to recognize that if an employee cannot exercise options and sell the underlying shares immediately after a company goes public, the employee will have to wait 1 year to be able to do that. I also caution you that if a company is granting options to employees who reside in provinces other than Ontario, you have to consider the securities legislation of the applicable province where the employees are residing. Now, most of the provinces have rules similar to our legislation, but you do have to examine those particular rules, and if the employees are in the United States, you have to have U.S. counsel help you consider the U.S. securities rules that would be applicable. I'm going to turn now to the rules of the TSE, because if you're dealing with public companies in Toronto, chances are you're dealing with companies listed on the TSE, although NASDAQ is becoming more and more important for us. The TSE has detailed rules applicable to option plans, and these are set out in Section 626 to 637 of the TSE Company Manual. And if your clients are listed on the TSE, you need to have a copy of the company manual in your office. And I'll just summarize briefly for you a few of the key aspects of these TSE rules. First of all, as to eligibility, the TSE allows an option plan to include employees and insiders or executives of a listed company or of a subsidiary, and also consultants, provided that the consultants are providing ongoing management or consulting services. The TSE will not allow you to include consultants who are providing a one-time service to the listed company. It must be ongoing. The TSE also has rules as to the maximum number of shares that can be included in an option plan. In the old days, the TSE had a rule that the maximum number of shares could not exceed 10% of the issued capital. Under competitive pressure from NASDAQ, a few years ago, the TSE changed that rule, and it's now open to a company and its shareholders to set the limit as to how many shares are to be included under an option plan, and that specific number must be set out in the option plan. Now, many companies do still limit the number to 10% of their issued capital. They essentially comply with the old rule because institutional investors do not want to see a plan that has, shares equal to 30% of your issued capital available for options. So companies have not tended to go wild, but it is now open to the company and its shareholders to, set that limit. The TSE has some additional requirements with respect to options. First of all, they cannot expire more than 10 years after the date of grant. That's the maximum term for the options. Subject to a few comments I'm going to make in a minute, the options must be non-assignable. The idea being that the option is to be an incentive to the executive or the employee and not to somebody else. So the executive cannot assign the option. The exercise price must not be lower than the market price of the shares on the TSE at the time that the particular option is granted. In the alternative, a reasonable predetermined formula based on a weighted average trading price for a short time prior to grant is acceptable to the TSE. So typical pricing mechanisms would include the closing price on the day prior to the grant of the option or a 5-day weighted average. But the TSE will not allow you to grant options at a discount to market at the time of grant. So if you're giving notice to the TSC of an option grant, it's important to get that notice into them, because if the market should go up, you'd be embarrassed if you then apply and they tell you it's at a discount to market and we're not going to allow that option grant. You should note that despite the company manual requirement that options be non-assignable, on application to the TSC will allow assignment of options in the case of the death of an optionee or to spouses, minor children, grandchildren, and personal holding corporations and family trusts. So they do allow very limited assignability. Now, with respect to vesting of options, which is when the employee can exercise the option, the TSC will allow immediate vesting of options. The TSC does not require that vesting be delayed. However, it's very common for companies to stagger vesting because they're trying to tie the employees to the company. So, for example, you could grant options that will vest 1/3 immediately, 1/3 in 12 months, and 1/3 in another 12 months. Turning quickly to termination provisions, it's very common for options to terminate some defined period after an employee's relationship with the company is terminated. For example, you might have immediate cancellation if the employee is terminated for cause, because the last thing you want is somebody who's terminated for cause to have options for the next 3 years. You might terminate 1 year after death or upon the employee reaching retirement age, or perhaps 3 months after any other cessation of employment. My paper refers to a line of termination cases that are important as to the wording in your option plan in these termination situations. Change of control, most option plans provide that if there's a takeover bid for the company, options will vest immediately because the takeover bidder does not want the options kicking around once the company has been taken over. The TSC requires shareholder approval if you're going to amend your option plan or if you're introducing a plan for a company that's already listed on the exchange. And as cited in my paper, in certain cases, the TSC will require that changes to options be approved by minority shareholders. For example, if an insider, the CEO, holds options and you're trying to reduce the exercise price of the option because the market has declined, the TSC will require that be approved by shareholders without that CEO voting his shares on that matter. And there are a few other matters discussed in the paper, but I'll leave it there for now.
Thanks, Ken. Next speaker is Shelley Obal, who's a partner in the research department of Osler, Hoskin, and Harcourt, who's going to speak about advising directors of an insolvent corporation.
No.
We're starting off with a height issue. Okay, I'm going to talk to you about how to develop a legal strategy to keep a board of directors in place in order to facilitate a debt restructuring under either the Companies Creditors Arrangement Act or the Bankruptcy and Insolvency Act proposal sections. In order to convince a board of directors to remain during a restructuring, you have to help them understand the nature and the extent of their liability and to help them develop a strategy to minimize those liabilities. And this process can be broken down into 4 steps. The first step is to take an inventory of the liabilities that face directors. And the types of liabilities you're focusing on are insolvency-related liabilities like source deductions for employees. Step 2 is to actually quantify the liabilities, put an actual dollar amount on what they may be. Step 3 is to categorize the liabilities as imposing either strict liability or providing a due diligence defense. And the reason you do this is obviously because the strict liability amounts that directors may be liable for are going to be the most problematic. And then finally, you have to develop a strategy for the particular business corporation to minimize the liabilities. And I'm going to focus my remarks on the 4th step. In my paper, I've gone through the other 3 steps. So any strategy to minimize liabilities is going to involve at least 3 things. It's going to involve establishing processes to support a due diligence defense. It's going to involve identifying sources of funds that might be available to pay amounts directors may be personally liable for. And finally, you're going to try to obtain director releases wherever possible. So one of the first orders of business is to put a due diligence defense into place, and that means using processes that ensure that the directors comply with their duties and that the corporation actually remits amounts when due. So the processes you put in place should actually protect directors by avoiding liability. However, if claims are made against directors, these processes will form the basis of the due diligence defense by demonstrating reasonable care. Directors should receive written advice from legal counsel about their responsibilities. They should also instruct the corporation's chief financial officer to remit all amounts when due, and this is very important. They should receive written confirmation that this has been done. The confirmation should be received on a regular basis, perhaps monthly during the restructuring, and should specifically reference the liabilities of particular concern to the directors. For example, again, source deductions. Now, as far as sources of funds go, you need to identify what money might be available to pay amounts that the directors are personally liable for. And again, this is really important for strict liability amounts. So sources of protection include the corporation's own assets, secured creditors, directors' charges or trust funds in companies' creditors' arrangement act proceedings, and possibly directors' and officers' liability insurance. So as far as the corporation's own assets are concerned, this part of the analysis involves identifying liabilities that have priority in a bankruptcy and are likely to be paid in any event. So if you take the example of source deductions, they have a super priority in a bankruptcy, so they're going to be paid out of the corporation's assets ahead of secured and unsecured creditors. Wages, including vacation pay, are a preferred claim in a bankruptcy up to $2,000. As far as secured creditors are concerned, it may be in their interests to keep the directors in place to facilitate the restructuring, so they may make funds available. And then turning next to directors and officers' trust funds or charges in CCAA proceedings, the court may give a charge over assets, or if there is cash available, may permit the corporation to set up a trust fund, but this is done very rarely and requires evidence that the board will resign if those mechanisms aren't put in place. And finally, we get to directors and officers' liability insurance. If the corporation has a policy in place, you have to review it to determine the amount, scope of coverage, and the expiry date. And restructurings can go over a long period of time, so the expiry date can be a huge issue because it means you have to negotiate an extension of the policy during the restructuring. Not all policies cover director liabilities associated with an insolvency. The type of language you're looking for in your policy will be usually found in the definition of wrongful act. And you're looking for language that says that the definition of wrongful act extends to claims made against directors solely by reason of serving in their capacity as directors. And I'll tell you that the coverage issues for D&O insurance in an insolvency are very complicated, and you usually have to work with the broker and the insurer to make sure everybody's on the same page. And a final strategy for managing director liability involves director releases. If you manage to successfully restructure under either the CCAA or the Bankruptcy and Insolvency Act proposal provisions, you get protection for the directors because you've managed to deal with the liabilities. You also get protection because both statutes now expressly provide for a director release in the statutes. Now, it's subject to some exceptions, but at least you can get the release in your plan or your proposal. So the process I've outlined is intended to help the board understand the extent of their liability and to help them manage their potential exposure. If the directors lose confidence in the process, their only alternative is to resign. However, the resignation isn't a panacea because resigning only avoids liabilities after the date of the resignation, not liabilities arising before that date. So you've always got to be managing the process, even if ultimately the board has to resign.
Thanks very much. We're running a bit behind, but we do have a few minutes for questions, if there are any. I have to repeat the questions because we're taping the episode, but I'll try to summarize it. And the first question is, in connection with the establishment of e-commerce businesses in Canada by U.S. corporations who are using a third party in order to promote, I guess, their business within Canada, where do you cross the threshold of them carrying on business on this side of the border? And secondly, how do you deal with a foreign entity such as an LLC when it comes to having to register that for doing business here in a jurisdiction in which the legislation would not necessarily recognize that? So,
They're great questions. As soon as that question comes in, then I've got the tax guys on the phone, and I've got the our corporate people on the phone, and you really have to get into the real detail. And I can't give you the tests right off, but I would say you've got to set up something where you're really seeing it as an independent contractor relationship, and that person is not able to execute contracts, anything along that line. And it's clear that it's more of a perhaps a commission arrangement, but there's not an agency relationship there, and I think you've got to be careful to set it up that way. But even if you're doing that, you really have to look at how they do it, the background facts to it in practice, because they may not be doing what you think, what you set them up to do in practice. And on the LLC, I really can't. You'd have to look at that jurisdiction by jurisdiction, how it would be treated here.
maybe we'll let Wayne.
Yeah,
Wayne's
I
probably
actually was thinking.
better position.
Yeah, there's an unproclaimed part of the Business Names Act was passed in 1998, hasn't yet been put in force, that allows for a LLC to be registered just through a business name, but it's not yet enforced. So right now, there's no way to validly register here. But some operate through subsidiaries.
Well, if there's nothing else, we'll break. Please, we're going to reconvene at 10:47. If you could make it 10:45, then we'll pick up and go from there.